know something? I'm sitting there listening to your mother. And man, understand something. You will never, ever possess the right to break her heart. You just don't have that right.
This hearing doesn't open like a routine legal proceeding. It opens like a warning. Judge Simpson is not just addressing the law here, he's addressing character. When a judge starts by talking about a mother's heartbreak, it signals something critical. The court is already looking beyond the charges and into the mindset of the defendant. Now focus on the underlying weight of this moment. Before any evidence is debated, before any argument is fully developed, the judge is framing the case around responsibility and consequence. That tells you one thing. The court is already concerned about behavior, not just the incident. And then comes the reality. This isn't a minor case. Carjacking, assault, financial fraud. These are serious felony-level charges. Combined, they suggest escalation, not accident. So right from the start, two narratives are forming. Is this a young man who made one bad decision? Or someone already stepping into a pattern of dangerous behavior? That question will drive every reaction, every ruling, and ultimately, the outcome.
Court calls the case, People versus Caleb Smith.
People. Lawrence Margolis on behalf of Mr. Smith. Caleb, please unmute yourself. Please state your name.
Caleb Smith.
Judge, we are still waiting on discovery in this matter. It's through U of M and they are notoriously slow. The video, we got discovery from the people, but I believe we're waiting on the video download from U of M. Is that correct, Mr. Prosecutor?
I missed what the last part of what he said was. I'm sorry.
We are waiting on the discovery download of the video from the U of M Department of Public Safety. I am not in possession of it as of this time. I had spoken with Mr. Chalmers, who was handling this previously. I know he's in trial. Do you have any update for the court on the video?
So I'm not familiar with how long it's going to take for that to be downloaded and sent over to you. I do see it looks like we sent some materials last month. I can reach out to U of M to see if there's a hang up on their end. But that's the best of my knowledge as far as the download and that process.
That'd be great. That's all I could ask for. Thank you.
How much time are you going to need to?
I can reach out to them today. I'm not sure how long it's going to take them to get back.
I sent that out for. Second. Probable cause conference. Go to March 6, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Your Honor, if people may be heard on bond, actually.
Yes, go ahead, sir.
Your Honor, the current bond in this case, I believe, is a PR bond. I would note that people initially requested $25,000 surety. I'll be renewing that request. The counts charged here, as the court can see, are carjacking, assault, intent to rob while unarmed, financial transaction device, as well as receiving and concealing.
Now the prosecution steps in. And this is where pressure enters the courtroom. Notice how the argument is structured. It's not emotional. It's strategic. Unknown victim, violent assault, physical injuries, attempted theft. Each detail is layered intentionally to build one conclusion. This defendant poses a risk. In legal terms, random violence is one of the most serious concerns for a judge. Why? Because it suggests unpredictability. If someone can attack a stranger without provocation, the court assumes they could do it again. Then comes the second layer, marijuana use while under legal supervision. On its own, that might seem minor. But here, it becomes symbolic. It signals non-compliance. It tells the court, even under pressure, this defendant does not follow rules. And that's where the prosecution shifts the focus from past actions to future risk. Because bond is not about punishment, it's about trust. And right now, the prosecution is arguing that this defendant cannot be trusted outside custody.
As far as the people's concern, it's public safety, and that this is a suspect or a defendant who assaulted a completely unknown victim, a stranger, in a parking lot, tried to take her car, took some property from her. She suffered a broken nose, chipped tooth, numerous abrasions. I believe it was then found later with other individuals consuming marijuana despite being under 21. I think that a PR bond is not appropriate given the severity of the charges as well as the facts of this case.
Mr. Margolis.
We'd ask Your Honor to keep the bond in place. This individual was charged originally as a juvenile. He spent 4 days in custody. The case was, he was released, and at the time it was dismissed and then it was recharged. We've been working with the detective in this matter, and we turned ourselves in. And then we're able to get the PR bond. Miss Burton Harris was at that hearing, or one of her people were there. I think she was at that one. I can't remember exactly that. Maybe that was Joe. He has no prior criminal history of any sort. He is an A student at Huron High School. He is on a house arrest tether. His mother is in the courtroom, or in the Zoom with Mr. Smith today. He is not a threat of committing any crimes. He is not a threat of leaving the jurisdiction. We would ask Your Honor to keep the bond in place. And there's been no bond violations. I don't believe. He said something about marijuana.
Is he testing?
I can't recall, Caleb. Are you testing? I think he did test, but I don't know if he is testing presently.
Testing for what? Sorry.
Alcohol or drugs?
No, they're not testing me.
All right, young man, if I tell you to report to community corrections today to take a drug test, is it going to come back clean?
No.
This is the first major turning point. The judge asks a simple question. Will the drug test come back clean? And the answer is no. Now understand the weight of that moment. In a bond hearing, the court is evaluating whether the defendant can follow conditions. Not big conditions, basic ones. And in one sentence, the defendant confirms he cannot. This is where things shift dramatically, because now the judge doesn't have to assume anything. There's no speculation. The defendant has demonstrated in real time a lack of compliance. And here's the critical part. It's not about marijuana anymore. It's about discipline. It's about control. It's about whether this individual respects boundaries at all. From this point forward, the judge is no longer evaluating potential. He's evaluating patterns.
What's going to show up?
It was from school. Just marijuana. That's it.
How old are you?
I just turned 18.
Yeah, that's a problem. Mr. Margolis, how fast can you and your client get down to the court?
Half an hour?
Pardon?
1/2 an hour?
Okay, I'll pass the matter. We'll see you then.
Thank you, Judge.
Thank you.
No.
Not at all, right? In fact, I'm just going to guess. I don't know your mom, but I'm just going to guess she's probably told you not to do it.
Yeah.
So you don't listen to her, and you're not listening to me or the court. You just want to play by your own rules, don't you?
No, sir. No, I don't.
Because otherwise you wouldn't have done it last night. Young man, how old are you?
18 now.
When was your birthday?
December 21st, 2006. It's my birthday.
So we turned 18 as I told the court, it was charged originally in a juvenile matter, and then it was dismissed and they recharged as adult.
You understand, young man, that you are facing a life offense.
Yes, sir. Yes, Your Honor.
You understand that?
Yes, Your Honor.
Now the courtroom hits a moment of absolute reality. The judge makes it clear. This is a life offense. That means the maximum penalty could be life imprisonment. Not years, not decades, life. And here's the contradiction that intensifies everything. An 18-year-old still in school, now standing in a position where his entire future is at risk. This is where judges test awareness. They're not just stating facts, they're watching reactions. Does the defendant understand the gravity? Does he grasp what's at stake? Because in court, perception matters. If a judge believes a defendant truly understands the consequences, there's room for leniency. But if they believe the defendant is still thinking casually, still minimizing the situation, that door starts to close. And based on the tone here, the judge is not convinced.
And it's taken a lot for me to realize what position I am in, and
I don't think you get it. You found yourself in a position where maximum penalty is life or any term of years. Have you graduated high school?
no, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules. So you tell me why, if you're just going to throw away your life, why I shouldn't just lock you up right now?
No.
You tell me why.
Improving, sir. And
Improving how? You're smoking last night. Tell me how that's an improvement.
I do it. I'm gonna tell you why. I usually need to study or focus study, and it helps me focus while studying. I listen to music, and I honestly no harm for it, and
You will never do it.
I would never do it again. I can do it whenever I'm not addicted to it or anything. I just like it because it helped me study.
Great.
I got good. My grades are improved now. Back since I've been out, I've been having
Did you tell your mother you needed something to help you study?
I said I prefer. I actually
Did you tell your mother that?
no.
This is where the case shifts from legal to personal. The judge starts focusing on the relationship between the defendant and his mother, and this is intentional. Judges often evaluate family dynamics to understand discipline and guidance. And what's revealed here is concerning. The defendant is making decisions independently, without communication, without supervision, without accountability. That signals immaturity. But more importantly, it signals resistance to authority. Because if someone does not respect the closest authority in their life, the court assumes they won't respect legal authority either. And now the narrative evolves again. This is no longer just about a mistake. This is about behavior that may not be correctable.
No, sir.
Because you're just so grown, you took it on your own.
Sorry. I was trying to do things on my own, and clearly I messed up. And this just shows that I need my mother to supervise me and to.
You're not listening to her. I don't, and I'll be honest with you, I went through the bond form, Mr. McGoes. I don't understand how he has a PR bond. I don't.
So the family would not be able to make a high cash bond or a significant money bond. He came to the court with no prior history of any misconduct. He is high school senior, on track to graduate. I explained to the magistrate how the family has all come together to take care of this, help assist this young man through this time. He's on a tether, on house arrest. All he is able to do is go to school and church. And I believe those are the two places that he's gone to.
Yeah, those are two places that I've only been.
He is not a risk of committing any offenses, not a risk of
Yes, he is.
any.
Because he did it already.
possible, and not to excuse anything here, Judge, but it's possible that I didn't explain the conditions sufficiently to this young man.
How's that feel with your sword in your chest?
I don't think I understand the court.
I don't mind attorneys falling on the sword for their client,
Thank
but
you.
this young man is not listening. He is not. He is just going to decide to do things his way.
Here, the judge cuts through everything: legal arguments, defense strategy, explanations, and focuses on one thing: behavior. I don't mind attorneys falling on the sword, but he is not listening. That line separates responsibility. The lawyer can argue, the lawyer can defend, but the defendant's actions speak louder than any legal strategy, and what the judge is seeing is a pattern, not a one-time lapse. Independence without discipline, decisions without reflection, actions without correction. And in a courtroom, patterns carry more weight than promises, because anyone can say, "I'll do better." But judges don't decide based on what you say. They decide based on what you've already shown.
And I think his problem is he's running to the wrong judge to try to do stuff his own way.
Understood, Judge. I would suggest that perhaps if he were to test regularly and prove to Your Honor that he does respect the court, does understand what he needs to do.
You know, Mr. Margolis, I don't mean to interrupt you.
No worries.
It's almost not so much about respecting the court, although I do require that. But you know, I'm sitting up there watching on the Zoom screen, and I see his mom just standing beside her child. And it's the fact that you don't respect her that is really irritating me. And because of that, you're not even doing the things to respect yourself. You're an 18-year-old kid up here facing life sentences for what? And again, I don't know your mom, but you got these charges come up, you got your mom scared to death.
If Your Honor would like to speak with her, she'd be more than happy to talk to the court. Right?
I'll tell you what, I'll hear from mom on my name.
Your Honor, and I probably mentioned this already, but he's in his last semester. My concern is that if he's detained for long.
Oh, I know.
Yeah, I know Your Honor knows.
I know.
I just wanted to put that out there. And
You know what? If I don't care about his education, about his life, what if he doesn't care? Why should I?
I think he does care. I think he's just made some mistakes. And
He's
improved.
not listening.
He's never talked to you before.
Oh, I can tell.
Meaning he's listening to you, Judge.
Mom, is there anything you want to say? I know this is not. Excuse me one moment.
Please.
Let me see where he wants her to speak. That right there, of course.
Put him over there with you, Alan, and then mom can come up so I can hear her.
Right here, man.
Mom, you can come on up. State your name.
Nicole Barrow.
All right. What do you
Thank
want?
Um,
What do you want to tell me?
And I know most moms would say that they have like a good kid and they give you this long spiel and then they do something bad and they're like, oh no, you should believe it. But when I tell you, like, I'm in shock, utter shock.
This is the emotional center of the case. The mother speaks, and the entire tone shifts. No strategy, no legal framing, just raw, personal truth. She describes a good kid, a structured upbringing, a future that made sense until everything changed. And this matters, because judges listen differently when a parent is honest. She's not denying the situation. She's not making excuses. She's expressing shock. That gives her credibility, but it also creates pressure, because now the judge must decide, does this background justify leniency? Or does it make the defendant's behavior even more unacceptable? Because from the court's perspective, a strong foundation followed by bad choices can sometimes be more concerning than a troubled past.
He was really a good kid and still is. I did not know. I knew he had a vape, but it wasn't marijuana. And I did tell him it was bad for his lungs. Prior to that, he was my only child that I knew for sure was going somewhere. He's never smoked, never been in any trouble. Him and his brother had started a business where they were selling hoodies in school. He would even be the one, helping me around the house. He's got a brother 16 months apart from him. I moved up to Ann Arbor 8 years ago so that he could go to a baccalaureate school because my two oldest children went to Cass Tech. His older brother went to Eastern and somebody laced his weed and sent him on a trip. By the grace of God, he came back. He's got a degree now. He's going to U of M this fall for software engineering. He even got a STEM scholarship. So that was the example that I was showing my younger children. Don't smoke weed. Don't hang out with these kids. Started hanging with some new kids that were older than him in college. And then I think turning 18, he thought he could,
Just
be
thought he was grown.
rebellious and grown.
Yeah.
Yeah, and not knowing. I just ask that the court show mercy. And I know this isn't something light or to be taken lightly, the charges that he's facing. We don't consider it lightly. We come from a good background. Our family, civil rights activists. I don't know if you ever heard of Willie Barrow, my aunt.
Yes.
Joe Lewis, my great uncle. I'm doing well at Blue Cross. I'm making a name for myself with the CEO. I'm back in school.
Ma'am,
So he comes
let
from a
me
good
stop
family.
you.
I'm sorry.
I do not doubt that at all.
Yeah. So this is hard.
I do not doubt that you as a mom have tried to do everything within your power to give him the tools and everything else so he could succeed. That is not a doubt. Like I said, I don't know you, but when I saw you on the screen, it wouldn't be easy for you, but if you just walked away from your kid that might have done wrong, I don't know that anybody would blame you necessarily. You didn't do that. You were standing cheek to cheek with him.
Yeah.
So understand any decision that I make, it's no reflection on you.
Sure. I understand.
But what I also understand is I've been doing this long enough to realize if he keeps getting away with this stuff, he's either going to end up in prison or in a casket. Don't shake your head because you have no idea.
This is one of the most direct and uncompromising moments in the entire hearing. The judge strips everything down to two outcomes: prison or death. That statement isn't exaggeration. It's based on pattern recognition. Judges see repeated trajectories: early defiance, escalating behavior, ignored warnings, and eventually irreversible consequences. What matters here is not just what the judge says, but how the defendant reacts. When the judge sees hesitation, disbelief, or resistance, it reinforces a dangerous perception that the defendant still does not fully understand the path he's on. From a legal psychology standpoint, this is critical. Courts are more willing to show leniency to defendants who demonstrate awareness and accountability, but when a judge senses denial or overconfidence, it signals risk. And risk is what drives detention decisions. At this point, the judge is no longer trying to convince the defendant. He's evaluating whether intervention needs to be immediate and strict.
You think you know too much, but I'm going to show you about what you do know. Mom, is there anything else you want to tell me?
He thought marijuana was legal and he could do that. And then they didn't tell us the probation. I know it's wrong, but they didn't give us restrictions or to anything to him. And I think he didn't know it because that's what he said coming in. If that, I know it's not helpful.
I got you.
I thank you
His
for
bond,
allowing
his
me.
bond conditions are what his bond conditions are. I understand they may not have told him, but you told him.
Yeah,
He knew.
I did tell him. And I just asked if you do make a bond, can you make it affordable for me? It's just me. And then I've been missing work already. I've missed almost a month. They're on me. I got to go meet with my HR on Monday about my job. This is so hard. And I told him I was only messing up at work because of this. I thought I could handle it.
Okay.
I'm sorry. I'm sorry.
No,
I'm
do
so
not
sorry.
apologize.
I'm sorry. I'm so sorry.
What time's your appointment on Monday?
In the morning when I go to work at 8 a.m. I work in Medicare Advantage out of the Blue Cross. It'll be 2 years in May.
What time do you get out of work?
4:30. You're right.
All right. Okay. You work, how far is it from your work to here?
It takes me about 45 minutes.
To get here?
Yeah.
All right. Okay. Thank you.
Thank you.
Anything else from either side before I do what I'm going to do?
Your Honor, the people's original request was for $25,000. That was before the people were aware of the new violation with the marijuana. This time, people will be requesting refunded for the violation. I know the court indicated I've gone through the bond request form. I know my colleague did a fantastic job outlining all the facts. I did just want to again emphasize the severe injuries and assault that occurred on one of the victims here with the broken nose, chipped tooth. She was bitten her hand as she was trying to fight the defendant for control of the car keys. I think remand is appropriate at this time.
Now the prosecution makes its final push, and it's focused, precise, and forceful. They return to the core facts: violent assault, physical injuries, attempted theft, and now a violation of trust through substance use. This is not repetition, this is reinforcement. In legal arguments, repeating key facts solidifies them in the judge's decision-making process. And then comes the conclusion: remand. Remand means immediate custody. No release, no waiting, no second chances at this stage. It's one of the strongest requests a prosecutor can make during a hearing like this. Why? Because it signals that the prosecution believes the defendant is both a public safety risk and a compliance risk. And at this stage, their argument has momentum, because the defense is presenting potential, who the defendant could become. The prosecution is presenting evidence, what the defendant has already shown. In court, evidence carries more weight.
Margolis.
I have nothing additional to add, Judge. This isn't the time to talk about the facts. We do have compelling defense to this case, but I'm not going to get into them now. This is the first offense, first charge of the lifetime for this young man. The family does not have money to pay a high bond. I would, if Your Honor was going to change the bond, I would suggest something in the range of 10 to 25,000, 10% if possible.
But if I make it higher than that, then family doesn't have it. And then he doesn't graduate.
Correct.
And everything's a mess.
Correct.
Anything you want to say?
Hold on. I just want to say that I do learn from my mistakes. I'm getting closer to God. I know.
This is the defendant's attempt to regain control of the narrative. He speaks about improvement, school, business, faith, personal growth. On the surface, these are all positive indicators. These are exactly the kinds of factors courts look for when considering leniency, but context matters. This statement comes after violations, after contradictions, and after the judge has already expressed serious concern about behavior. That timing changes how the message is received, because now the judge is asking a different question. Is this genuine change or reactive response? Courts are trained to identify the difference between proactive reform and situational regret. And when improvement is only presented after consequences begin, it can be viewed with skepticism. The defendant is trying to rebuild credibility, but the foundation has already been weakened.
I do look at my mistakes and I know it impacts my family and I know it impacts my mother and it really breaks my heart. I've been improving. I've been improving in school, my business. I'm helping opening up a business today actually for pregnant women for a pregnancy pillow. Like I'm trying to like do the right thing and I won't smoke again. That's no problem for me to not smoke again. I won't like other than that, like I've been following my probation rules. I've been texting my probation officer. I've not committed any other violations. I've been going to school on time. And I really apologize to the court. I'm sorry. I apologize to you. And that's it.
You know something? I'm sitting there listening to your mother, and then understand something. You will never, ever possess the right to break her heart. You just don't have that right.
The judge returns to a central theme, the mother. This repetition is not accidental. When a judge circles back to a point multiple times, it means that point is influencing their decision. The focus here is responsibility, not just legal, but personal. The judge is emphasizing that actions have consequences beyond the individual. Family, trust, and support systems are all affected. And by bringing this up again, the judge is reinforcing a key idea. This is not just about breaking the law. This is about breaking trust. That distinction matters, because violations of trust are often judged more harshly than violations of rules.
Normally, an easy thing for me to do is to accede to the people's request. If I accede to the people's request, you're not out. You don't graduate. Everything becomes a whole mess. But it also seems that if I let you out, you can't seem to follow the rules or do anything. So what I'm going to do is I'm going to think about it. And I'm going to decide what I want to do. But you're not leaving here today, Mr. Allen. What I'm going to do is I'm going to revoke your bond. You sit there and you think about it. I'm going to set a bond hearing 4 o'clock on Monday, 4 p.m.
This is the decision point. The judge revokes bond, immediate custody, and this outcome is not sudden. It is the result of a sequence: serious charges, non-compliance, lack of demonstrated discipline, and concern about future behavior. Bond revocation is not punishment. It's precaution. It means the court no longer believes the defendant can be safely or reliably managed outside custody. And once that trust is gone, reversal becomes difficult. This moment defines the immediate future of the defendant, no longer preparing for court from outside, but from inside a cell.
I'm setting 4 p.m. so you can get into the building. Ma'am, get to work. You get here. We'll be here. We'll wait for you. Okay? We'll finally have somebody that's waiting on you as opposed to you waiting on everybody else and everything falling through. But what you're going to do, young man, since you can't seem to understand what kind of life you're kind of headed to, you ever been in jail?
Yeah.
For how long?
They put me in here for 4 days.
On this case, Judge.
Well, you're going to be back in. And then come Monday, you might just stay in. You have nobody to blame for this but you. So at this time, defendant is remanded. We'll see you on Monday.
This case concludes with a clear outcome. The defendant is remanded, a young individual, a supportive but shaken family, and a judge who ultimately prioritized control, compliance, and public safety over potential and promises. The broader takeaway is direct. Courtrooms do not operate on intentions. They operate on actions, patterns, and demonstrated behavior. Every opportunity given is conditional, and once those conditions are broken, consequences follow quickly. This case reflects a critical legal reality. Early decisions, even small ones, can shape outcomes in ways that are difficult to reverse. If you found this case as impactful as it is instructive, make sure to hit that like button, share your perspective in the comments, and subscribe for more in-depth courtroom breakdowns.